Your entire presentation, as did Mr. Clement, takes out our regular articulation of standing. In Meese versus Keene, we said a candidate has standing when the defendant's conduct would substantially harm his chances for re-election. In Clapper, we said substantial risk of harm. In Murphy, we said substantial risk that in the near future the plaintiff will suffer an injury. Both of you are sort of ignoring that language because you're saying, you're almost arguing in a circle. It's always a substantial risk because it might happen, which is plausibility is never what we've accepted. Maybe Justice Kagan is right. Let's talk about what the electoral disadvantage is here. What do you see if we use something like that accounts for the cases that Mr. Clement argued, like whether or not I will have to pay a greater amount or accept a lesser amount? That's electoral disadvantage. Someone else might pay less and I might pay more. But where's the electoral disadvantage here?
So,
meaning all the voters, Democrat and Republicans, get the same chance to have their vote counted. So it's not a harm to either side that the people voting for them are going to be equally treated.
So I just want to push back on the premise. We're not saying just because a risk may happen, there's a substantial risk. The plaintiff has to be a direct object, and the harm has to immediately
That's where we
flow
go
from
back to, is he or she the direct object?
So
we're going to have to now change our standing to say indirect objects or people who are part of the scheme in any way. But even in Diamond, the fuel manufacturers were not part of the regulatory scheme.
But in the electoral context, and I think the electoral context is, and especially rules governing the validity of ballots, is unique in this sense because the purpose of those rules, almost the only purpose for a rule saying this ballot counts but this ballot doesn't, is to determine which candidate wins the election. So it is targeting the candidate's concrete
Can you
interests.
answer the question, what's the electoral disadvantage in this case?
Well,
Given the allegations of the complaint, let's deal with that. What can you show me in the complaint that articulates electoral disadvantage?
So our rule doesn't turn on electoral disadvantage, partly because vote counting rules ex ante, it's impossible to know which way they will break, or often it's unknown which way they will break.
Justice Alito said you could. You could have a long history of, you have proof since 2005 of where these things have broken, and you could have alleged that.
Our rule doesn't exclude standing based on electoral advantage. I think one of the things our rule gets at, to the extent electoral advantage feeds into our rule, part of the gamble, so two answers, part of the gamble or part of the reason it's a concrete particularized harm to candidates is if they don't expend resources to mitigate the cost of this substantial risk, then they are giving up potential and electoral disadvantage.
Thank you, counsel.
Thank you.